I am Adrienne Molenkamp of the League of Women Voters of Athens County. Welcome to this informational forum for Ohio State Issue 1. We hope that this will provide you with information for the upcoming election. Please make sure that you have a voting plan. Early voting started yesterday. You can contact your County Board of Elections office to find the location and the times of your early voting. If you want to vote by mail, you must submit a written absentee ballot request form. We recommend submitting those forms as soon as possible to allow time for mail delivery of your ballot. Election day is Tuesday, November 8th. You can verify your polling place by contacting your County Board of Elections. In addition to candidate events, our Athens County League publishes a voter guide with information about candidates and issues. Voter guides created by our league and other leagues around Ohio are available online at vote411.org. The League of Women Voters is dedicated to expanding public awareness about government issues and encouraging active participation in government. The League does not support or oppose political parties or candidates and has not taken a position on state issues 1 or 2. Please visit our website at athensleagueofwomenvoters.org to learn more about the League or to become a member. Membership is open to anyone at least 16 years old. If you appreciate our election events and voter guides, please consider making a donation to the League. Thank you. Before we begin the Issue 1 forum, I want to tell you that there is also another statewide issue on the ballot this fall. Here is the ballot language for Ohio State Issue 2. It is a proposed constitutional amendment that would require that only a citizen of the United States who is at least 18 years of age and who has been a legal resident and registered voter for at least 30 years can vote at any state or local election held in this state. Issue 2 would also prohibit local governments from allowing a person to vote in local elections if they are not legally qualified to vote in state elections. This ballot language and a list of pros and cons are available at vote411.org. Tonight's forum is about State Issue 1. Here is the ballot language for this issue. Issue 1 is a proposed constitutional amendment that would require Ohio courts, when setting the amount of bail, to consider public safety, including the seriousness of the offense, as well as a person's criminal record, the likelihood a person will return to court, and any other factor the Ohio General Assembly may prescribe. Issue 1 would also remove the requirement that procedures for establishing the amount and conditions of bail be determined by the Supreme Court of Ohio. Tonight, we are joined by Louis Tobin, Executive Director of the Ohio Prosecuting Attorneys Association, who will present the pro side, and Patrick Higgins, Policy Counsel at the American Civil Liberties Union of Ohio, who will present the con side. We appreciate both speakers for making the time to participate tonight. Now I'll turn this event over to tonight's moderator, Catherine Jellison.
Thanks, Adrienne. Well, welcome to the Issue Forum. I will begin by explaining the forum procedures, which the speakers have received in advance. Tonight's forum will include an opening statement from each side, questions submitted by the public, and a closing statement from each speaker. The speakers will have 5 minutes for their opening statement, 2 minutes for their closing statement, and 1.5 minutes to answer each question. There will be no rebuttals. The order for speaking will rotate, and I will indicate who speaks first. The speakers can see our timekeeper, John Howell, who will indicate when the speaker has 30 seconds remaining, 15 seconds remaining, and when their time has expired. If someone continues speaking, I will say thank you and move on to the next speaker. All questions were received ahead of time and were reviewed by a lead panel to identify duplicate questions. In that process, we sometimes combine similar questions. If you don't hear your particular question, it could be combined with a similar question. We will attempt to cover as many questions and topics as possible in the time available, wrapping up by 8 o'clock. We now begin our opening statements. Louis Tobin will speak first. You have 5 minutes, Lou. You may begin now.
Well, thank you, Catherine, and thank you to the League of Women Voters of Athens County and the other chapters across the state who are watching tonight. I appreciate the opportunity to talk with you about State Issue 1. But just quickly about the OPAA, we are a statewide organization that represents Ohio's 88 county prosecutors. Prosecutors come from obviously various size counties, various political backgrounds, and have various points of political views. It's important for everybody to understand that to us, this isn't a political issue. It's universally supported by prosecutors, regardless of where they come from and what their background and what their political inclinations are. To us, it's about public safety. It is about protecting communities and keeping dangerous offenders away from the victims and from committing more crimes. And I think there are 4 key points that I want everybody to take away tonight. The first is that all Issue 1 does is give discretion back to your local elected judges to consider public safety, along with a variety of other factors like a person's income, their ties to the community, whether they're employed, the seriousness of the offense, the person's criminal history. Public safety will just be considered along with everything else when judges are setting a reasonable amount of bail. So we're giving discretion back to judges. They're in the best position with input from the prosecutor, from the defense counsel, from the victim to assess the situation, to assess the facts of the case, and to decide whether bail is needed, what the amount of bail should be, or whether other steps need to be taken to make sure that a person's going to show up to court and not obstruct the criminal justice process and not damage public safety. 2, it's important to understand that this doesn't create a wealth-based justice system or a wealth-based bail system in Ohio. Nothing about State Issue 1 allows a judge to set excessive bail. It says that the judge is to consider public safety when they set a reasonable amount of bail. The Ohio Constitution is still going to have a clause in it that says excessive bail is prohibited. Defendants are still going to have a remedy if they feel like excessive bail has been set. That's a habeas corpus proceeding that they'll file in the Court of Appeals. So nothing about this is going to allow judges to all of a sudden start detaining people because they're not wealthy. Third is that this is not mutually exclusive with the bail reform legislation that's pending in the General Assembly. You can be for State Issue 1 and for giving discretion back to your judges, and you can still think that the General Assembly should pass bail reform of some sort. You can have it both ways. Nothing about State Issue 1 prevents the General Assembly from enacting legislation 2. And in fact, there was language specifically included in Issue 1 that says any other factor as established by the General Assembly. And that was intended to allow bail reform advocates to continue to advocate for that. And then the final point is that public safety is supposed to be considered. We think that the Supreme Court got the DuBose decision wrong based on how Criminal Rule 46 reads, based on how various statutes in the revised code read that are related to bail in Ohio, and based on the Ohio Supreme Court's precedent and United States Supreme Court precedent. And specifically, you know, the court relied on Criminal Rule 46. And so I think it's important for everybody to understand what exactly Criminal Rule 46 says. A few important lines from Criminal Rule 46. In B, it says, if the court orders financial conditions, those financial conditions shall be related to the defendant's risk of non-appearance. Now, if they got the DuBose decision right, the rule would stop right there, but it doesn't. It goes on to say that they shall also consider the seriousness of the offense and the previous criminal history of the defendant. Those are 2 clear public safety related topics, the seriousness of the crime and what the person's criminal history is. And the rule says that courts are supposed to consider that when they're setting financial conditions of bail. 2, in Division C of the rule, it says that courts are to consider all relevant information. And part of that is, and then it lists a number of topics. And it says that they're to consider all relevant information, including but not limited to the nature and circumstances of the crime, and whether the defendant used or had access to a weapon. Again, those are clear public safety related considerations. And we are just trying to get a judge to consider all relevant information. Surely public safety is a relevant consideration, along with other factors like the person's income, their ties to the community, their employment status. We just want judges to consider everything that's relevant in making these decisions and setting a reasonable amount of bail.
Thank you, Lou. We'll next hear from Patrick Higgins.
Awesome. Thanks, Catherine, and thanks, Lou, for getting this kicked off. Thanks to everyone, including the league and those of you that are tuned in, for being here tonight. Can't stress enough how important it is, regardless of where you come down on this, just to learn about the issues, which we will make sure we do everything we can to get more information out about. So my name is Patrick Higgins. I am policy counsel at the ACLU of Ohio. We're an affiliate of the ACLU's national organization, which champions and expands fundamental and other constitutional rights for folks around the country and in our state. So we're 26 days away from the election. Again, thrilled to be here speaking about this important issue. I think this is an important moment for a number of reasons that, I'll outline pretty similarly. But just to note the gravity of the moment of we're being asked to amend our state constitution. And we're being asked, and I hope you reflect on this throughout the night as well, which is, what does public safety really mean to you? I think it's important to note that it's not defined in issue 1. So it's an important thing to consider as we think about which way we want to go with our future of public safety in Ohio. So I think we all deserve to live in safe communities. We all have constitutional rights that protect us from unconstitutional interference with our freedoms. So I hope, among the many things that you take away from tonight are, the reasons that are core to our belief that issue 1 is not right to Ohio. And I say that, and this is an area that Lou and I disagree, which is that the DuBose decision, we think, was a straightforward, correct reading of the law. We think Rule 46 is clear. We think the history of cash bail, distinct from some of the other ways that bail can be set and folks can be released from jail pre-trial, we think that reading of the law was correct, which is that the primary purpose of using cash in bail is to make sure that a person comes back for their trial date. It's not to punish a person. It's not a gauge of their morality. It is to make sure that there's enough money on the line that they come back for their trial date. And so when we think about that, we're also thinking about what really does keep our communities safe. And we know that throughout history and today and in the future that cash bail is not the solution for public safety. And I say that because, let's say myself and someone else that's in the audience tonight commit the same crime today, after this forum tonight. We're having the same circumstances, same danger to the community, hypothetically, but we have different amounts of money in our pockets. When a person can post bail in those same circumstances, but another cannot, we think that's unfair. We think that's unjust, that amount of money can determine their freedom. We think it's unfair that a person could purchase their freedom. Along that same line, and I think, it's important to say, although not the topic of the debate tonight or the forum tonight, is that we do have an alternative before us. And Lou mentioned that there is an alternate mechanism for bail reform pending in our state legislature. It's been there for 513 days. So when we think about the urgency of public safety that folks who are supporting issue 1 are putting out in front of voters and saying, we need this right now, the public is less safe, I say that's wrong. And I say we haven't acted on this alternative that's in the legislature and really does focus on public safety in a different way. I think lastly, just to kind of wrap this up, when we think about what public safety means to us, we're talking about our communities, we're talking about human beings. And so when we're thinking about this pretrial system, which is large, costly, expansive around the state with over 12,000 people on any given day in Ohio jails sitting there pretrial before they've been convicted of a crime, we're talking about our neighbors. We're talking about people who are legally innocent. We're talking about people who, while they sit in jail, cannot pick up their children from school, cannot go to work, cannot pay their rent because they're not going to work. And so we're thinking about human beings. We're talking about people navigating the system who have a real human impact in whatever we decide to do in November. So I thank you for being here again to learn about it. I hope it's informative and looking forward to the discussion tonight.
Thank you. Now we move to the question and answer portion of the forum. Speakers will have 1.5 minutes to answer each question. These questions were all submitted by the public. If either of you need a question repeated, please ask me and I'll be happy to do so. So we will go first to Patrick. What spurred the Ohio General Assembly to propose this particular amendment to the Ohio Constitution?
Great. Thank you for the question. I think there are a few things that spurred House Joint Resolution 2, which was a precursor to Issue 1. First and foremost, it was the DuBose v. McGuffey decision, which we've both mentioned already tonight. I think what came from that, though, also was the at least public expression of communities are less safe because of this decision. But I think it also creates, and this is something that, thinking back to what's happening in the legislature, is that there's some motivation behind this beyond just the instant, DuBose case. And I think that's this public safety issue is one that, people are concerned about. It's on the ballot. It's one that folks can talk about in their campaigns. And I think people see Issue 1 as a driver for votes. And I think, when we think about public safety, I make that distinction because, I don't see it being a true focus on bail reform, which Issue 1 is not. And so I think the motivation is to drive voters out this November, and I will wrap up my time there.
Lou, what is your answer to that question? What spurred the Ohio General Assembly to propose this particular amendment to the Constitution?
I think it was the fact that the decision in DuBose kind of flew in the face of the plain reading of Criminal Rule 46, which had gone through the General Assembly and gone through a public process where specific language is included that was related to public safety, and it was expressly included for that reason. So in my opening statement, I talked about the language about the financial conditions of bail being related to flight, 1, being related to the seriousness of the offense, 2, and being related to a person's criminal history, 3. The original version of Rule 46, before it went through the General Assembly, stopped at financial conditions. And it said if a court is setting financial conditions, those conditions shall be solely related to a person's flight risk. Because of concerns that were raised in the General Assembly about that, the General Assembly encouraged the court to reinsert the seriousness of the offense and the criminal history of the offender. And they did that before the rule was enacted by the court. And so I think there was no point in having that public process if the court was just going to ignore the changes that the rule underwent during that process. And I think that's really kind of what set the General Assembly off.
The next question is one of clarification. You both have been talking about the DuBose case. Could each of you explain, starting with Lou, exactly your understanding of the DuBose ruling?
Yeah, so it's simple. The court said that courts who are setting bail can consider public safety related reasons when they're establishing non-financial conditions. So things like GPS monitoring, house arrest, stay away orders to stay away from victims and witnesses. The court said that public safety is relevant to non-financial conditions. They said that if you're going to set financial conditions of bail, those conditions are solely related to flight risk. And that's the DuBose decision in a nutshell.
Patrick, is that your understanding of the decision?
That is my understanding, yes. I think one other thing that I will point out from the results from that decision is it was also made clear that when either courts or prosecutors have a concern so great that a person is a danger to the community, is that courts do have a tool. It's called preventative detention. It's revised code 2937.222, which allows courts in a hearing that protects the rights of the defendant to deny them bail altogether. So instead of setting cash bail so high in an amount that a person could never hope to pay for their freedom, there is a mechanism by which a court can use to deny that person bail.
Thank you for clarifying that for us, both of you. Our next question will go to Patrick first. A close examination of the present law as to bail indicates that public safety is addressed by non-financial conditions of bail, such as negative drug test screens, house arrest, stay away orders, mandatory drug counseling, and other requirements. Are courts able to protect the public and alleged victims with these sorts of conditions alone?
So my short answer to that is yes. Courts can protect individuals with, conditions of release. There are a whole array of different conditions of release that a court can impose on a person. Can include, everything as restrictive, which, we wouldn't want to see in every case, but everything is restrictive as monitoring where that person's going, what they're doing, to, less intrusive things like you already mentioned. So I think, yes, conditions can protect the public. And I think, again, going back to my recent point, that if that concern is so grave that a person cannot go back to their community, there is a mechanism beyond just a condition of release that can prevent a person from obtaining bail altogether.
Lou, how would you answer that question?
I think, yes, sometimes non-financial conditions can protect the community. I think by and large, most people who are in an arraignment hearing are being released on their own recognizance or are being released with some sort of non-financial conditions of bail. I think for most people, that's probably fine. There are, however, offenders who get placed on electronic monitoring units and cut the monitoring units off and fail to show up for court, or go on to harm victims and witnesses and go on to commit other horrendous crimes. So there are other people who non-financial conditions just aren't good enough for. The other issue with it is that, I think some people in the public have this perception that there's somebody watching. If somebody's placed on electronic monitoring or placed on house arrest, that there's somebody sitting there monitoring where they are at all hours of the day, and they're just not in Ohio. So, you can place an electronic monitoring unit on someone and they could go to the victim's house and no one would ever know it unless the victim had called the police. So I think to a certain extent, electronic monitoring and house arrest provide a false sense of comfort.
Thank you. This next question, Lou will answer it first. One of the arguments in favor of this amendment is that it gives individual courts more discretion in determining cash bail. Can you explain how, if this amendment is adopted, courts will actually have more discretion?
Yeah, it 100% gives judges more discretion. And I think, as I said again in my opening statement, we think judges are in the best position to do that. They're most familiar with the case. They're most familiar with the defendant most of the time. And so, right now, after DuBose, a court might set bond for a violent offender at $50,000 because the only thing the court can consider is whether that person is a flight risk or not. And let's say they've got a little bit of a criminal history, but they've always shown up for court. So they're not really a flight risk. You want to set a low bond and get them out of jail. On the other hand, you might have somebody who's got that same criminal history. It's a violent criminal history. Now they're in front of the court again on another violent offense. Pretrial detention might not be an option for a variety of reasons. And so maybe the court just increases the bond from $50,000 to $100,000 or to $150,000 to give that person a little bit more skin in the game.
Patrick, how would you answer this question?
Sure. Discretion is not a word that I would use. I think requiring that the courts do consider something else is not giving individual judges more discretion over that. I think, beyond that, adding a requirement that public safety be considered, shouldn't necessarily change, that exact amount unless bail is being set to an amount that's excessive or more than what's required to make sure that person shows up to their trial date. And so, I guess short answer, no, don't agree that this is more discretion. But beyond that, I think that, even if we were to accept the fact that this is more discretion, don't think it does anything to really add to this public safety analysis.
Thank you. This next question will go to Patrick first. The Ohio Supreme Court presently sets the rules as to criminal procedure. If this amendment is adopted, the General Assembly will set the rules as to bond. Is it wise to remove the Ohio Supreme Court from rulemaking on the question of bail?
Short answer is no. That's something else that I'm glad is raised as a question because I didn't get to it in my opening statement, which is that this is a significant shift in power, essentially. That as things stand right now, before issue 1, is that courts create the rules for the procedure in setting bail, and in that is where we get the Rule 46 that's also at the center of a lot of this today. And if issue 1 were to be successful, that rulemaking authority would be taken from the Supreme Court of Ohio and given to Ohio legislators. We think the court is in the best position to be making those rules. And frankly, I think, it gets a lot messier when we put it in the hands of the legislature rather than going through the Supreme Court.
Lou, how would you answer that question?
Well, I think it's unquestionable that issue 1 gives the General Assembly more authority to set the parameters of bail. But Article 4 of the Constitution still gives the Supreme Court procedural rulemaking authority. So I don't think there's anything about issue 1 that takes away the court's authority to set procedural rules for anything. And I think that includes bail. So I think while we're taking some authority away from the court and giving it to the General Assembly, the court is still going to have rulemaking authority and procedural rulemaking authority for the courts of Ohio.
Thank you. This next question goes to Lou first, and it is an issue that has come up previously in tonight's discussion, but I think it's worthwhile to provide more discussion on this issue. Wouldn't this amendment disproportionately impact lower income people who typically have more difficulty raising cash bail than wealthier people?
My answer to that is no. Nothing about this, again, creates a wealth-based detention system. It allows judges to set bail, an amount of bail that's reasonable based on the circumstances. So if you've got a wealthy person who's in front of you for a bail hearing and you're worried about them being a danger to the community, the judge should take that into consideration, along with everything else, just like they should for somebody who's not wealthy. I think even more importantly, though, is the fact that, at least in Columbus, and I think other major metropolitan areas in the state of Ohio and across the country, most crime is occurring in underserved neighborhoods. And most victims are people who are minorities who don't have a lot of wealth themselves. And those people deserve justice too, and they deserve safe communities too. And they deserve to be able to get up in the morning and go about their business and provide for their families and go to their jobs without having to worry about whether they're going to be victimized. And I think the problem with opponents' position to state issue 1 is that the very people who they claim to want to help are the people who are going to be most hurt by their policies, because the people who are going to get released are going to go back to those neighborhoods and commit more crimes.
Patrick, how would you answer that question?
Sure. This is certainly a place that we disagree, and I think the answer is yes. That I would distinguish between. I don't think this creates wealth-based detention because I think we already have that, and I think what issue 1 would do, if successful, would be to quite literally enshrine the use of cash bail into our state constitution. And so when I say that, what I mean is that we know that there are people in our jails around the state who can't afford their bail. Some of the proponents of issue 1 say that those people don't exist, but I encourage you to read some of the stories that we featured about those people. And so, yes, I think if we're relying on cash as a proxy to consider public safety, that ultimately, yes, there are going to be people who cannot afford their bail, and that does result in wealth-based detention. And to respond, just a little bit of time that I have left, yes, I think people in low-income communities deserve justice, even those who are victims of crime. I think the justice they deserve is to live in a community with less crime, with less wealth extraction, and with less damage caused by our criminal legal system and wealth-based detention. So certainly agree on that point.
Thank you both for your answers to that question. Again, this next question has been dealt with to a certain extent earlier this evening, but this really focuses on some particular language in the amendment. And this question goes first to Patrick. The amendment adds language that reads thusly, and any other factor that Ohio General Assembly may prescribe. And removes the requirement that the procedures for establishing the amount and conditions of bail be determined by the Supreme Court. Isn't this an effort from one branch of the government to take control of another branch of the government? Shouldn't we be troubled by this? The person who submitted this question has asked it.
Sure. I think, yes, good to revisit this question. I think, yes, this is, a constitutional amendment proposed by joint resolution. So from our General Assembly, seeking to have voters give that power from the Supreme Court of Ohio to the legislature in setting those conditions. And, frankly, we do find that concerning. We see year over year continued, penalties for folks coming out of our state legislature. We want to see, we want to see a world where there's, fewer and fewer folks going into our jails and prisons. And I think, as a result of that, we to get back to answer your question. I'm sorry, I'm drifting a little bit, but, short answer is yes, we do have concerns about that.
Lou.
Well, I think that position is interesting because that language was explicitly included for the proponents of the bail reform bills going through the General Assembly so that they were comfortable that they could continue to debate those bills. I quite frankly would have been happy if State Issue 1 didn't include the language about the General Assembly having the authority to establish additional factors. But that's why it's in there. It's in there as a fig leaf to people who want bail reform so that they can continue to advocate for bail reform.
Thank you. Again, this next question by a member of the public deals with some issues we have discussed already, but allows further discussion. And it goes to Lou first. Will the amendment, if passed, result in more racial disparities or more income disparities than we have now with regard to the setting of bail? If so, how and why?
Again, I don't think so. All we're doing is telling judges that they have to consider public safety along with a bunch of additional factors that they already have to consider. And the rule already says that judges have to consider all relevant information, and certainly public safety is relevant too. And again, I would just go back to the point that I was making a couple of questions ago that, a lot of crime happens in underserved communities. A lot of defendants are come from those communities. They're victimizing the people who are in those communities. It doesn't have anything to do with the fact that they're minorities. It has to do with the fact that they lack access to the same type of opportunities that people in wealthier neighborhoods have. But I think the majority of people who are coming from those underserved and minority communities are people who are just trying to go about their day and provide for their families and go to work. And I think we're risking their safety and risking their ability to bring themselves up by their bootstraps by saying that by default, we've got to release the people who are terrorizing their neighborhoods without considering the safety and the harm that they're causing to those neighborhoods.
Thank you. Patrick.
So short answer again is yes. I think we see in our current, status quo and reliance on cash bail that the weight of our reliance on cash bail, like all things in our criminal legal system, falls most heavily on our Black communities and our low income communities. And so I think, as we, through issue 1, the state considers further entrenching that in how we carry out our pretrial system in the state, that would naturally be the result. And so, I think time will tell, but I think we're confident in the data that we have now and what we can tell now that will be the case after issue 1 as well.
Thank you. This next question was obviously submitted by someone who knows something about the law. And it goes to Patrick first. Should courts be, and it's a multi-part question. Should courts be expected or empowered to use cash bail as a means of holding individuals who are deemed dangerous? Why is money part of this conversation? Aren't there better mechanisms where dangerous individuals could be held regardless of financial resources? And this questioner gives as an example, couldn't ORC 2937.222, which allows courts to deny bail when certain serious offenses are alleged, be expanded to cover all violent offenses?
So again, yes, there are other mechanisms, or there are mechanisms for denying people bail if the court does not wish for that person to go back to their community. It is 2937.222. Like I mentioned before, we'll just flag there, and I promise not to keep diverting to this, but when we're talking about in this other, in this whole world of bail reform, that those initiatives happening in the legislature that we consider true bail reform do make expansions to that list, which would make a remarkable number of offenses eligible for preventative detention in those cases. So yes, and definitely agree that cash is not the right tool for keeping people detained for fear of public safety.
Lou.
I'm in favor of expanded pretrial detention. My organization is in favor of expanded pretrial detention if it's in addition to and not in lieu of judicial discretion to consider public safety when setting the amount of bail. I think preventative detention is a great option, but it's not always the best option, and here's why. The preventative detention statute allows the person who's accused of the crime to call witnesses. And so there are going to be cases, and the classic example is a child sexual assault case, where the only way to keep the person detained is going to be to have the preventative detention hearing and give the defendant the opportunity to call the child witness who they've just sexually victimized and cross-examine them. And that's going to happen within several days of the crime having been committed. Other examples of that are domestic violence offenses, where a woman might be stuck in, or a man might be stuck in the cycle of violence, human trafficking offenses, where the victims might be subject to the control of their trafficker. All of those victims are going to be subject to being called and re-traumatized within days of the crime having happened in order to keep their offender in jail pre-trial. And the great fear is that for us is that it's going to have a chilling effect on the whole process, that fewer victims are going to be willing to come forward, that the victims who are willing to come forward are going to end up recanting because they don't want to face their offender that quickly. And so that's the problem with pretrial detention.
Thank you, Lou. This next question goes first to you, Lou, and it is a variation on a theme that we have discussed earlier this evening. The Ohio Constitution presently gives the Ohio Supreme Court the power to set the rules of criminal procedure. So if this amendment is adopted, will there be a conflict in the Ohio Constitution?
Again, I don't necessarily believe so, because Article 4 still gives the Supreme Court the authority to set the rules of procedure. I suspect that there will be end up being some debate between the General Assembly and the Supreme Court about exactly where the Supreme Court's authority stops now and where the General Assembly's begins. But the court still has procedural rulemaking authority. I think that was certainly still applied to bail procedures. I'll leave it at that.
Patrick.
Yeah, I would, I think this is an area where we have a lot of crossovers. It's certainly, there's some uncertainty here. And I think uncertainty is not, a good thing to have going into such a significant decision. And so I'll leave it at that. There's lack of clarity here. And, I think where there is lack of clarity, there is potential for conflict.
Thank you. The next question goes first to Patrick. Some concerns have been expressed by people in the healthcare community about the effect on the health of people who will be incarcerated because they will be unable to post bail while they wait for trial. Please address this concern with regard to the proposed amendment.
Sure. And I think, what I imagine this is referencing, and if not, I apologize, is the Health Policy Institute of Ohio put out a study about pretrial incarceration, which is a great resource. And I think certainly we know that, again, if we're, using, in this instance, public safety as a means to incarcerate someone pretrial, especially through the use of cash, we know that the folks who are sitting in our jails pretrial, who again are legally innocent, that there are significant consequences to single days, especially after 3 days of sitting in jail before a trial date. So again, not just those showing up for work, picking up your kids, but we know that there are health risks as well to being incarcerated. So whether that's people not getting the quality treatment that they would get had they been released, access to medication, things like that, which can get sorted out over time, but certainly in that short period of time can be problematic. So I think vast array of consequences to being incarcerated before one's trial date, and certainly includes health outcomes as well.
Well, I'd hate to be dismissive of the question, but I'm not sure that's necessarily related to state issue 1. Again, we're not talking about allowing judges to set excessive bail all of a sudden. We're just requiring them to consider public safety when setting a reasonable amount of bail. But to try to respond a little bit to the question, I think there are huge secondary health effects of crime and violent crime as well. In Columbus just this week, last night on the Hilltop, a 13-year-old kid was shot and killed. Earlier this week, a 15-year-old girl was shot and killed on the east side coming out of her high school. In August, there was a story in the news here that there have been 5,700 car thefts in Columbus through August. And so that's 5,700 people who came out of work or woke up in the morning and tried to go to work and maybe weren't able to get there because their car had been stolen. There are gigantic secondary costs to society of crime and of violent crime.
Patrick. We already did that. Excuse me. Lou goes next with this question, which I must say is one of my favorites. Are there any other questions we should have asked you about issue 1? And then
that is a good question. I think we've run the gamut. I think just an interesting point, I think, because all of this, I think, surrounds the DuBose decision. Ohio is a Marsy's Law state. And I think I'd be remiss if I didn't talk about the fact that Marsy's Law gives victims, crime victims, the right to be heard in public proceedings. And so in the DuBose case at the trial court, the victims got to present why they were afraid of Justin DuBose. They got to talk to the trial court about that. That's one of the reasons that Justin DuBose's bail amount was set at what it was. The Court of Appeals changed that bail amount without hearing from the victims, I think arguably violating their victims' rights. And then the Supreme Court upheld the Court of Appeals decision without hearing from the victims, which arguably violated the victims' rights. And we just shouldn't lose sight of the fact that we're talking about protecting victims and preventing future victimization and in terms of requiring courts to consider public safety. And that's really what we should be most concerned about, is the people who just get up and try to go about their day and have things taken away from them, sometimes everything taken away from them by people who are up to no good.
Now it's Patrick's turn. Are there any other questions we should have asked you about issue 1?
I think to answer the question with a question is, so when we're really drilling down to, what's behind issue 1, what's the point? And if we're working from the standpoint that any bail amount that is more than what's required to get a person back to their trial date is excessive, then how could within the bounds of the 8th Amendment, which prohibits excessive bail, within those bounds, how will consideration of public safety and promotion of issue one actually protect public safety? What is the mechanism within this cash bail usage that will actually keep the public safe?
Thank you both. Those are all of our questions from the public. So we'll now move to closing statements. And Patrick will go first. Each of you will have 2 minutes for your final remarks.
Certainly. So I'll just start with, extreme amount of gratitude for Catherine, for John, for Lou, for being here. I know there's areas that we disagree that were very evident tonight, but I think, just remarkably important in this process of making sure that folks are informed when they hit the polls in just over 3 weeks. So, I think just to reiterate some of my takeaways from today is that the undertaking in issue one is great. We're talking about amending our state constitution to enshrine cash bail. What I'll also point out again is that we don't think that the fix that's proposed by people backing issue one is a fix at all. We don't think there's a problem that needs fixing here. Beyond that, we've outlined again that there are alternatives in our legislature, including other legislation that protects the rights of victims through Marcy's Law from being called at different hearings and phases of this process. And lastly, and I'll wrap up with this, is that there are real human lives on the line here. And yes, we all want to live in safe communities. We all deserve that. The people who are navigating our pretrial system are legally innocent. They have families, they live in communities. They also have a big price to pay here. So when we're thinking about this whole picture, I hope that folks who are tuned in today are thinking about what public safety truly means to them, what the mechanisms are to get there. And I hope that they'll consider, all of this information when hitting the polls in a few weeks. And so I will just give one last plug to more resources from our end about this, in addition to those that are already out there, which is at ohbailreform.com. You can find more information from the ACLU of Ohio and other folks who are opposing issue one there. So thanks again for your time, and appreciate all of you that are here.
Thank you, Patrick. Lou, your closing statement.
Well, I would echo the thanks to all of you, and thanks to Patrick for the discussion. And certainly I appreciate his point of view, even though we vigorously disagree, I think. I would just start by my closing argument by reading something that is from a United States Supreme Court decision called United States versus Salerno. And, the Ohio Supreme Court in DuBose said that when you set the amount of bail, the only thing you consider is whether a person is a flight risk. And this is what the United States Supreme Court has said. Nothing in the text of the bail clause limits permissible government considerations solely to questions of flight. The only arguable substantive limitation is that the government's proposed conditions of release or detention not be excessive in light of the perceived evil. While we agree that a primary function of bail is to safeguard the court's role in adjudicating guilt or innocence, we reject the proposition that the Eighth Amendment categorically prohibits the government from pursuing other admittedly compelling interests. Public safety is unarguably a compelling interest of the government. It's one of, if not the primary reason that government exists, is to protect the public. All we're trying to do is to get judges to consider public safety along with a variety of other factors and anything else that the court considers relevant when deciding whether a person should have bail, what the amount of bail should be, whether they can be released on conditions of bail, or whether potentially they should be ordered detained altogether. We want to give courts more tools. We want to untie their hands. The DuBose decision has tied their hands, and judges are in the best position to decide that. They're locally elected. If people aren't happy with the decisions that they're making, either because they're letting the wrong people out or keeping the wrong people in, that's why we have elections. We just want to give the judges more tools. We want to go back to where we were pre-DuBose, and other debates about bail reform can continue to take place.
Thank you. I'd like to close this forum this evening by thanking both of you for taking the time to participate in our democratic process. A recording of this forum will be available on the League of Women Voters of Athens County website and Facebook page. And finally, I want to thank everyone who submitted a question or tuned in to learn more about this issue. We urge all of you to make a plan for voting now. Early in-person voting is available now, and Election Day is November 8th. Thank you all and have a good night.